immigration. Can Donald Trump give you a green card? Hey guys, before you file for your spouse, hey guys, come on in, type in freedom now. Freedom now. We have some very important breaking news that we're going to be covering today on this live session. In addition to your questions, I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in freedom. I hope you guys had a terrific weekend. Come on in, say hello, say where you're watching from, put in your city and state or country if you're joining from overseas. It's great to have you guys here today. I hope you're feeling energized and good. We're going to be talking about two breaking news. We have two big things that happened over the last day. One happened yesterday on Sunday night involving the House and their move to fund the mass deportation plans that Donald Trump, the Trump administration has, in addition to what I'm going to start off with, the point that the government is now making regarding green card holders. So come on in, say freedom now, freedom now, freedom now. We can be reached, guys, at our phone number 914 898-9488. So you can contact us and speak with one of my colleagues about an appointment with us. Friends, we're here for you. And I hope that you're staying quite informed. If you're joining today on Facebook, share this live session with your feed. Thank you guys so much for being with me. So the first big issue that we need to discuss is the fact that this administration, as you guys know, are really making inroads or efforts to roll back on the legal immigration process, and they have been doing so methodically since January 20th, 2025. And what they are now up to, all right, green card holders. I believe it was last week, right? And I'll pull this article up for you guys so that you could see. This was last week. This is May 13th. The administration is arguing, the Department of Justice is arguing that they have the power to revoke green cards at any time. It doesn't matter if you had been a green card holder for 10 years, 15 years, 50 years. The government made a decision on your green card case. They are now arguing very strongly in court, and this is before the Third Circuit Court of Appeals, that they have the power to revoke your green card for any reason, well, at any time. At any time. Okay. Now I'm going to take you into the argument that they're making here. The Justice Department argued during a Third Circuit hearing last Tuesday, that the Attorney General has full authority to demand reconsideration of green card holders' residency status at any time. A shift that if accepted by the court could radically impact the nation's more than 12 million permanent resident. And this is the article coming out of Courthouse News Service. Okay. And it goes on to detail the fact that there's a Palestinian-born man and longtime New Jersey individual who had been granted a green card through an immigration court process by an immigration judge years ago. And I'm not going to get into the technicalities of his case, but his case, the government, even after the judge gave him the green card, the government has filed various motions and such to really get this whole thing reconsidered. They have their suspicions about him and his activities. That's their argument. But the big point that I think you need to pay attention to is the fact that they are now arguing that they could reopen a case at any point. Okay, how is my connection? Is my connection good, loud and clear, crystal clear on your end? So they're making the argument, friends, that they could reconsider these decisions to grant individuals a green card. They could do it at any point. And they're arguing that there's no limitations under the law that place some sort of time limitation, so to speak, on their ability to do that. And the article goes on to say that effectively suggested that any green card holder's residency could be reconsidered at any time for any reason. And one of the judges, this is a three-panel judge here, three-judge panel, one of the judges said, well, that's an extraordinary position for the government to be taken, don't you think? Congress has provided, the government has answered that Congress has provided the executive through the statute with broad discretion to regulate matters of immigration. So the DOJ, Department of Justice, is saying that they have broad authority, broad discretion as granted by Congress to handle anything related to immigration. And one of the judges said that, she resisted the government's position, suggesting such a legal interpretation could theoretically upend the nation's entire immigration process. And she asked, what, if any, limit is there on the Attorney General reviewing the adjustment of status going back 50 years, guys? And so this is the back and forth that occurred during this Third Circuit discussion. And I'll do another video about this, but I do want to end by quoting one of the judges who asked this very question. Is it possible to frame it the other way, which is to say, there isn't really ever finality in an immigration system? There are tiers and steps that could, at which point status changes, but nothing is ever final, even including naturalization. There are always grounds by which the sovereign can then go back and say, the grace by which we have extended your permission to remain in the country has changed. So this is one of the judges' position here, that to take such an extraordinary position would basically to say, well, even if we granted you a green card and then even naturalization, we could, as the sovereign, we could come back in and just take it away from you. And that would be truly extraordinary. So this is, in my opinion, something that you guys really need to pay attention to. What happens in court matters. It matters for every single one of us, okay? So when we talk about these cases, guys, please listen to what is being discussed here, because this is being played out even right now, okay? These things are being played out. So that's the first breaking news. I'll get into the second breaking news momentarily about what happened on Capitol Hill, but I'm going to go ahead and answer some of your questions before I touch on what happened yesterday on Capitol Hill with the House of Representatives, okay? All right. Thank you, guys. Let's see. Let's keep going. Freedom Now. The first question is about naturalization. You recently mentioned that the naturalization process will change. Can you explain more about that, and when do you think it will happen? So, yes, so I have been speaking about the fact that now is the time, I think, in my opinion, for naturalization, because there's speculation that things are going to become a lot more difficult with becoming a U.S. citizen, as we can see, right, with like everything else that's happening with immigration, guys. And so naturalization changes. I don't have the specifics in terms of what is to come. I don't want to, put out theories. I want to definitely tell you what they're going to do once it's rolled out. Okay. So just be a little patient, but certainly we know through the grapevine that they're making strides to change a whole lot with our system. So just keep that in mind. So now naturalization is still intact, of course. The process has not changed in a significant way. And so go for it. And, same day appointments, same day being sworn in, same day as your appointments for the test is happening in some places. Yes, it has happened in the past. It's not anything new, but it is definitely not something expected under this Trump administration. It is happening in various jurisdictions, including New York. So get your filing in, guys. Good to see you guys. Hey there, Nikki. Hey there, Michael. Hope everyone is well today. Marcia, great to have you as usual. Guys, if you're just joining, I shared some breaking news involving the government's position now that they're arguing in court very strongly that they have the power to revoke anyone's green card at any time and for any reason. And that is a real extraordinary argument that they are making at this time. That's what you missed. Watch the replay of today's live session, okay? Let's see. All right, great question about removal of conditions. If married to a U.S. citizen and we've been together for almost 4 years and we filed for removal of conditions almost 2 years ago, can we file the N-400 for naturalization? Naturalization, yes, can be filed early in a marriage case. If you've gotten your 2-year green card through your spouse, absolutely, you can do it at the 3-year mark of being a resident. It doesn't matter really how long you've been together for this naturalization purpose. It's so long as you've been a resident, you've had your green card for 3 years, then you can seek naturalization, or 2.9 years. Type in freedom now, guys. It's great to see you. Great to see you. Okay, I don't have the update quite yet prepared, Gina, regarding TPS for Venezuelans. We will get that news out to you guys in a more thoughtful way very soon. Thank you. Freedom now. Let's see. Let's see. May says I-130 is approved and the appeal is dismissed after a motion to remand. I-130 approved, appeal dismissed after motion. Okay, how much time normally do we need to do a filing for adjustment of status? So here you have your I-130 case. First of all, you need to be working with a lawyer on this one. It's a complicated situation. I don't know about the timing of the aspect of it with what you're asking specifically, but I will tell you this, that once your I-130 is approved and you're eligible for adjustment of status, you can file for adjustment of status right away if you're eligible for adjustment of status after your case, your I-130 case was denied. You appealed the decision, you won your appeal, which is great, and you have a good I-130, so you can proceed with adjustment of status if eligible. All right, thank you. Good to see you, Gloria. Freedom now. All right, come on in, guys. Come on in. Let's go down here to this section. Okay, here's a question from the super chat asking about VAWA and such. Would you recommend filing a new I-130 if I'm waiting on VAWA since 2022 and would like me to remarry? So here you have a person who has a VAWA case pending, but in love with someone else and has moved on with his or her life and considering a marriage case. For some people, what we normally do is we normally look at the strength of that VAWA case. I never tell anyone when to get married, who to get married to, or anything like that, ever. What I do look at is the merit of the case that you currently have pending with the government and let you know that, you know what, you could possibly finish up this process successfully. And you're close to the finish line, right? So if you're close to the finish line and it's very well possible that you could get your green card, then why mess around? right? Why mess around with a new process and disqualify yourself from that new process, from the old process? All right, guys, come on in. Type in freedom now. Let's see. Let's see. Freedom now. Freedom now. Thank you. Good to see you. Freedom now. Let's see. I'm not sure what's going on here. Let's go to this question. Waiver. Okay, so this person, Natasha, says, I have an approved 601 waiver and have an appointment for my green card interview. Should I go? I've been in the US for over 30 years. So you're asking whether you should go to your interview. So friends, normally, obviously, when you get an interview notice from the government, you should comply with it, because if you don't show up for your interview, they will deny your case. If you're very concerned about why you should not go to the interview, speak with an attorney privately about those concerns. You have a 601 waiver approved. The 601 waiver addresses things involving fraud, misrepresentation, crimes, various health grounds, and some other things. So, most people are fine, but you could speak one-on-one with us if you I don't know when your interview is. We might not be available to meet with you before your interview, but speak with your attorney about these concerns and fears that you have about going. Why are people afraid of going in? They're afraid because they're hearing that USCIS is very aggressive now. They've heard from me. I've been reporting out on it. I've been telling you that they've changed. They are more like a law enforcement agency, so you've got to really know what you're doing. However, cases are still being reviewed and approved each day, and we shared those stories and receipt notices with you. So they're working, but you've got to understand that they are of a different philosophy and mission now. So if you have serious concerns about going to your interview, speak with your lawyer, who could then advise you that you have nothing to worry about and I'll go with you, or the lawyer might advise you in a different manner. Freedom now, guys. Freedom now. Thank you so much for being with me here today on this beautiful Monday afternoon, where we're talking immigration. I'm scrolling down. There are a lot of comments, a lot of questions. Let's see. Okay, green card through adjustment of status after a visa overstay. Can this be grounds of inadmissibility at customs after overseas travel? So so if you have a green card, you shouldn't worry. You're going to be fine. Most green card holders are fine at the airport and they're coming in normally without any problems. So if you've gotten your green card and you have a clean background, no major no real strong criminal problems on your record, and you got your green card the right way, you should be fine with travel. Nothing to worry about there. And they can't use the fact that you've overstayed your visa as a reason to not allow you back into the US as a green card holder. You've already passed through that level of scrutiny and you met the requirements to get your green card. All right. So don't worry about it. I know people are like on edge. I'm speaking to people these days who have very, very minor problems in their history, but they're still on edge. They're even green card holders with minor things, but they're on edge. Guys, relax a little, but stay informed and educated, because I shared breaking news in this one about the fact that the government is arguing strongly in court to be able to go back and revoke anyone's green card whenever they choose to. There's no time limit on that. So that's what I shared today. Now I'm going to briefly touch on another breaking news that you really need to know about. And With regard to this breaking news, friends, this has to do with mass deportation efforts that the Trump administration has been proposing and planning, which you guys see it's not really being played out the way that the government hoped and dreamed that it would be played out. But yesterday, on Sunday, Congress acted. The House Budget Committee members met and they voted out on that reconciliation big beautiful bill that we've discussed before, that would allow for a significant amount of money to go towards immigration enforcement. And when we last touched on this topic, I have a video out there on it, a live session. We're going to put the link here so that you guys can watch that video, in which I broke down for you not every, but a lot of the different areas that this bill targets for immigration enforcement. And so it was, at the time when we spoke, it was $81 billion. I'm not sure if the House Budget Committee did anything differently with that amount quite yet. And the vote, they voted this out of the committee. It passed by party line vote of 17-16. And again, this is Sunday night that this happened yesterday. And they're expecting to vote. The House, the full House now of Representatives, is expected to take this up early this week. And then the Senate will be involved in this process. Friends, this big, beautiful bill through the reconciliation process would essentially have ICE, the ICE's detention budget will go from 3.4 billion to 45 billion, which would create 100,000 new beds, 100,000 beds, provide 8 billion to hire more law enforcement agents. 14 billion would be earmarked for deportation efforts, 600 million to investigate and prosecute immigration matters, 75 million for expedited removal, 25 million to remove immigrants without future hearings. Okay, things like that are in here, in addition to a ton of fees. This bill raises 77 billion in fees to offset the costs, including an asylum application filing fee of $1,000. Work permits would be renewable every 6 months. You would have to renew a work permit and pay no less than $550 for it. There's a lot in here. I had broke it down for you guys in a different video, so go back and watch it. But keep an eye open for this one, this reconciliation package, guys. It will really give the government a huge boost towards those deportation efforts that they're seeking. So I will be sure to share more information with you once the House acts on this week. Guys, let's keep going. Hey there, Henry. Good to see you. Angie, thank you for being here. Let's see. What are the consequences withdrawing the N400 application after the first one? The first interview failed. You might not face anything significant after withdrawing your N400 naturalization application. Withdrawals of an application really becomes a problem, more so, I think, in marriage cases, complex marriage cases, when it just depends on the timing of when those applications are withdrawn in a marriage case. That's when it could really hurt someone and cause them to be placed in removal proceedings if it's not done properly in the marriage case context. I think you'll be fine with your N400 application withdrawal, okay? Let's see, Freedom Now. Okay, someone says that I have a niece who is living with me. She's 14 years old, and I want to send her back to her mother, to the Bahamas. Do you think ICE will take her off the plane when she travels, or would she be traveling with a flight attendant? So here's the thing. When an individual has made the decision that they're leaving the United States, the government is not looking to stop them unless there is some outstanding warrant for their arrest or something like that. That's a different scenario, and that doesn't involve a 14-year-old. So if you've made that decision to send her back, that's your decision to make. At this point, ICE is not targeting children to, on that level. They're not targeting children, okay? You're welcome, May. Good to see you. Thank you for your question. I'm waiting for a long time for my visa. I've visa interview date for Nairobi embassy. I've received NVC notification telling me that my case has been approved or I'm documentarily qualified. So I shared with you guys that the State Department has a really great tool now that tells individuals how long they should expect to wait, right? So to speak. Once the case is documentarily qualified, they give you that information. Now, under this administration, they're making this data tool available, which is terrific. I don't have that link here, but I do have a video out there on it. It was one that last 2 weeks ago when I did live sessions. I forget the name of the video, actually. I don't even know what the thumbnail title is. But if we're able to find it during this live session, we'll put the link here. But you could just Google State Department visa interview tool, and you might be able to find it that way if we're not able to post it during this session. Thank you guys for being here. We were talking earlier about green card holders and the government's argument now in court at the Third Circuit Court in a case that is making headlines. And in that case, the government is arguing that they have the power to revoke or take back anyone's green card at any point. There's no limitation. And the court had a big problem with that. One of the judges said that nothing is ever final, even including naturalization. There are always grounds by which the sovereign can go back and say, the grace by which we have extended your permission to remain in the country has changed. That's the question, that the judge raised because it's, seems so far-fetched, this argument, but that's what they're arguing now in court. All right, let's go, guys. Freedom Now. I was given an interview date and I sent in a written request to reschedule it. Does it take a long time to get another date? Daniel is asking. Sometimes it does, Daniel. Sometimes it does slow down the process and take a bit longer. It just all depends on what's going on there. But generally, yeah, that will slow it down for you just a bit. What does it mean when they want you to come in for an interview? This is an immediate family filing. What does it mean? Well, for this, under this administration, they are performing more interviews, okay? It might not be anything crazy that for you to think about, like, okay, they're going to take some action against me or something like that. No, it's just now the routine that USCIS has. That's their routine to bring everyone in now for an interview. You mentioned that this is an immediate family filing. Is it a marriage case? But in marriage cases, absolutely, they are interviewing pretty much everyone these days. But you might not have anything to worry about. It's just routine, standard routine at this point. Okay, let's go. All right, Freedom Now. I have a work permit through TPS, and I have my pending green card application, I-485 and I-130. If I applied for a work permit through adjustment of status, would I have to wait for that to be approved to work if TPS designation gets canceled? So your work permit, you might just go from have a nice smooth transition. Of course, you should not work without authorization. One thing to note is that with an immediate family filing, the government, there's an exemption, looks the other way with regard to work. But you have a work permit, you'll probably go through a smooth transition to the next one. So I don't think you have that much to be concerned about. I'm seeing more here about the Supreme Court allows Trump administration to end protection for Venezuelan migrants. We're going to look into getting out some more details about that to you guys. All right, so just stay tuned on that. We have a busy, busy day here. Okay. I've answered that one. Let's keep going. If my spouse cheated on me and I divorce her, would I still be able to obtain my green card, or do I have to stay married to her? I'm just waiting on my interview to go to Mexico. Go to Mexico for my interview. So, so the decision to divorce or or stay together, stay with your spouse, that's your personal decision to make. Nothing for a lawyer to really weigh in on in this kind of context. For some people, they are eligible to just keep the process going on their own without their spouse all the way until the end. It gets a little trickier, however, and it won't work in the context of consular processing. It's very difficult to pass through the embassy scrutiny if your marriage is not intact any longer, because sometimes the embassy surprises individuals out of the blue and asks for certain bona fides related to the marriage. Sometimes they even call a spouse, not always, but we've had cases like this. That's what I'm speaking from experience, okay? Occasionally they might call a spouse and one, or other times, and this is a case that we had that we won, it was a very complicated case. They asked the spouse, the US citizen spouse, to fly to that country. I believe this was Georgetown, Guyana, to appear at the interview with his wife, okay? And so sometimes they do things like that. And if they do, then it could really be a problem, because if you're no longer together with the spouse, at that point, you won't be able to get your immigrant visa and return to the United States. So just some special issues to be aware of, okay? Freedom Now, Akuba, good to see you. Lavanda, thank you for being here. Hope you guys are doing well despite everything, despite all that's going on. Should someone file the I-130 and I-485 at the same time? It may be, if they're eligible to do that. They call this concurrent filing, and not everyone is eligible to do adjustment of status here in the United States. They and a lot of people, common mistake that a lot of people make is thinking that they could just do adjustment of status, when in fact, if they're in a preference category, like maybe they're an adult and their parent is filing for them, if they're like 30 and the parent is filing for them, they think, okay, I could do adjustment of status. And that's not the case, because a visa is not available. So with adjustment of status, a visa has to always be available, and it's available only for certain groups of people. Just do a little research on that and you'll see what I'm talking about here. Vera, good afternoon. Thank you. I just got my green card. Oops, where's the question? I just got my green card. Oh, no. Just got married to a green card holder. Is it wise to apply now to change my status, or let my husband go for naturalization first? Lexi is asking. So Lexi, if your spouse files for you now, it's just an I-130. It's just an I-130 case. No visa is available quite yet for you, and you'll have a receipt. If you're the type of person that says, well, you know what, I want to have my receipt and show that I'm on track for getting a green card, then now is the time for you to obviously file your case. Because, and also, where are you located? What's your jurisdiction? What's the enforcement environment like where you're located, having an I-130 receipt could be a very good thing to show that you're on track to you're married to your spouse and you're on track to getting a green card. But you won't be able to adjust. For some other people, they're making the decision. I don't necessarily think now is the environment to make this decision, but some people are making the decision that I'll just wait until my spouse naturalizes. He's going to naturalize in a year or two or whenever. I'll just wait. And then I'll just do adjustment of status at that point. And I respect that. Absolutely. And before the Trump administration, that was always the advice that I gave folks, that you could just wait. It's fine. It's not that you could wait. You could wait. Right. And it might even benefit you to wait, because if you're married longer than 2 years, then you'll get a 10-year green card but when you file your case. So that's the advantage to wait in. But this environment is so tricky right now. So we have to reconsider all of these issues and reconsider how we're advising clients. We're shifting with the times, okay? Shifting with the times, all right? All right, let's see. Guys, tell me where you're joining from. I have no idea where you guys are watching from today. Karine, Freedom. Where are you joining from? Let's go down. Go down. All right. Keisha is asking, what if you have a removal order and you had an interview for the I-130? What does that mean? Keisha, it means you're on track, okay? And you could only do your I-130 now. And once your I-130 is approved, then you've got to work with either your lawyer or contact us, or whoever you choose to contact, work with someone to do the next step. And the next step, Keisha, has to be the reopening of that removal case, okay? That's so you're on track, which is great news. You're on track. Should you be worried if you have a waiver pending? Should you be worried? Well, I don't think you should just, I don't think you should just be worried. Okay, don't answer it here. A lot of questions that I'm asking is not for you to answer here. Some things for you to think about and discuss with a lawyer privately, one-on-one. Thank you guys for joining during this lunch break. If you're just joining, I shared that the House Budget Committee passed yesterday that beautiful bill out of committee, and it's going to be taken up for a vote by the full House sometime this week, early this week. And it includes a lot of money for immigration enforcement. We've talked about it before. Go watch those videos from last week or the week before. And then I also shared that the government is pushing a very strong argument right now in the Third Circuit Court of Appeals that they have the power to go in and revoke anyone's green card at any time. It doesn't matter if they've been a green card holder for 10 years, 20 years, 50 years. They have the power to do it, and they want to do it, and they're doing it for this one man right now, whose case is before the Third Circuit Court of Appeals. Freedom now, guys. Let's see. Let's keep going. Is travel to a red country still an issue? The travel ban hasn't arrived yet, right? I talked about it a lot, and it's not here yet. And it went super viral. We're still expecting it. Still expecting it. I still don't think it's a great idea to travel to a red country on that list. Why not? Because we don't know when that shoe is going to drop. We have no idea. Okay, but we do know that the State Department is right now actively revamping a lot of their policies, changing things around, expanding their authority and powers to do various things. And they are looking to restrict the flow of folks into the United States. So this is something that we really do believe is coming very soon. So I don't think it's, in my opinion, I don't think traveling to a red country at this time makes sense. You guys have been given a lot of time to get your affairs in order if you're overseas as well, because we talked about this a while back. So you've been given quite a bit of notice. Um, any idea about the diversity visa lottery? Do you think they will try to end it? I think that they will try to end it, yes, because Trump is not a fan of it. I think they made some attempts under Trump 1.0 towards that end, but they weren't successful. They did, however, slow down a whole lot of people from coming into the United States back then, and some people did not get through, some of those lottery winners. But I don't have any update today about any attempts recently with regard to diversity visa. Let's keep going. Let's see. I have a green card, and now I remove the condition and have a letter. Is it safe to travel internationally? Zahir is asking. Yes, Zahir, probably, yes. It could be fine for you to travel if there's nothing crazy in your history. When I say crazy, guys, I think you know what I mean, okay? Um, in your history, you can travel, okay? Now, it's at your own risk, of course, but like I said earlier, most green card holders travel with no problems. You could even travel on that extension letter, the 48-month extension letter. If you're going through a process of removal of conditions and they've sent you your 48-month extension. Oh, this is okay. Should you be worried about being picked up by ICE if you have any pending process? I don't think you should worry, but speak with an attorney about what's on your record or in your history or background that could potentially make you a target for immigration enforcement. Again, we started off this year talking about their enforcement priorities being individuals with a criminal record, individuals with a removal order, individuals who came into the country under 2 years, less than 2 years ago, right? Who have been here for up to 2 years, something like that. And now we've seen over the course of time that they have really broadened and expanded this to just about whoever they could find, even those who are simply making the wrong turn, traffic stops, traffic violations. We've seen them really expand on it. Why? Because it's very difficult to reach those who they really want to reach because folks know their rights and are not opening those doors because they understand the constitutional rights. So that's what we're seeing now. And I've since forgotten what the question was. I don't even remember what I was asked. Okay. Can a green card holder travel outside of the US this summer? I think green card holders will be fine to travel. Okay, let's see if I could take maybe one more. Can I travel with my old ID? I have the ID without the star. So the Real ID Act is in effect, actually, and it doesn't only apply for travel, it applies for federal buildings as well. Some federal buildings are enforcing it, including some where you're going for your immigration interview, right? But most USCIS field offices are not enforcing it quite yet. So you can still travel with one of those TSA approved IDs, like a foreign passport, but just know that the Real ID Act is in effect. Guys, we're going to, I do see that 29 super, I'm getting a whole lot of this about the TPS for Venezuelans. Have you seen that?
Yeah, it just came out like 30 minutes ago.
Can you send me the article right now so that I could cover it, please? Okay, so guys, hold on while I'm getting that pulled up. And just if you could just maybe print it for me, please. Thank you. I want to talk about that. So let's go. More questions. Okay, Joan is asking a question that caused my eyebrows to go up like, okay. Okay, so what if someone that you know gets a work permit under false circumstances, what if, let me just read it to the way that you guys are seeing it on the screen. What if you get a work permit under false circumstances without your knowledge? I don't know how the without your knowledge part comes into play here, because to get a work permit, an individual will need to sign the form, the I-765 application for work authorization, for the work authorization card. So I'm not sure, I understand about how false circumstances work, but without your knowledge, unless someone you committed perjury, then you might have a case, right? You might have a case as a victim of fraud that you could speak with an immigration attorney about. But for most individuals, obviously everyone, they have to sign their own immigration paperwork. And by signing your own paperwork, the government believes that you understood what you were signing and that you were the one who placed the information or consented to the information that's on your application, okay? Thank you, guys. I had my marriage-based interview in Maryland in February. Oh, I had answered this one before. The interview was great, but I have not received any update from them. What do you think I should do? I think there's nothing for you to do if you were interviewed in February. It's you just gotta wait for the next step, and for most people, the next step would be an approval letter. Okay. I got my green card 3 months ago. Congratulations, Marco. Should I travel internationally? If you choose to, if you have that clean record, nothing to worry about there. You should be able to travel. All right, let's see. I have 1 year with no update on my case for my wife on a spousal petition. I have 1 year. How long does the process usually take? Roberto is asking. Spousal petition process. So Roberto, it's taken more than a year. Is your spouse a U.S. citizen? If your spouse is a U.S. citizen, then you're looking at something like maybe 15 to 18 months. I have my consultations starting momentarily, guys. So I'm going to quickly go through this. May 19th. Okay, so the next what I have here in front of me, and this is from who? I don't even, okay, so AP News. AP News is reporting that the Supreme Court on Monday, today, allowed the Trump administration to strip legal protections from 300, can we start this one, please? From 350,000 Venezuelans, potentially exposing them to deportation. And this is definitely bad news. And I'm sorry to be the one to share it with you. Okay. Thank you. The Supreme Court today allowed the Trump administration to strip legal protections from 350,000 Venezuelans, exposing them potentially to deportation. The court's order, with only one noted dissent, put on hold a ruling from a federal judge in San Francisco that kept in place TPS for the Venezuelans that would have otherwise expired last month. The justices provided no rationale, which is common in emergency appeals. The status allows people already here in the United States, as you guys know how TPS work. It allows folks to stay here, work, and be in lawful status while their country is designated as a TPS country. This is really devastating news. A federal appeals court had earlier rejected the administration's request to put the order on hold while the lawsuit continues. The case is the latest in a string of emergency appeals the Trump administration has made to the Supreme Court, many of them related to immigration. Last week, the government asked the court to allow it to end humanitarian parole for hundreds of thousands of immigrants from Cuba, Haiti, Nicaragua, and Venezuela. This is not the news that we wanted to have today, but I'm sorry to now share it with you. Some of you already knew. That's why you were telling me in the comments below to talk about this. So this news will impact most of those individuals, most of the Venezuelans. There are some, however, who are able to successfully transition to a green card through a different process, immediate relative process. Some people already have their applications in, although the government has paused those applications at this time, but the government must adjudicate those once the pause is over. So this is breaking news out of the Supreme Court today that TPS for Venezuelans is allowed. The court is allowing it to end. So when I get more information on other things that are pending at the Supreme Court, you guys know also that the issue regarding birthright citizenship was heard last week by the U.S. Supreme Court, not whether or not it can end, but whether a nationwide injunction can be placed to stop an executive order that calls for the end of birthright citizenship. That was really the issue being discussed that was discussed last week at the U.S. Supreme Court. So we're waiting on that issue regarding the nationwide injunction, whether a nationwide injunction can stop any executive order for that matter. And if the Supreme Court rules that nationwide injunctions are an overreach, so to speak, of the judiciary, then what the scenario that could set us up for with birthright citizenship is that some jurisdictions can enforce it and stop issuing the birth certificates until parents or individuals file lawsuits that would place an injunction in that district, in that locale. And then other places, children will be issued the birth certificate because, they're not there. Maybe there's an injunction. So it sets us up for this, just a real terrible dynamic. But the nationwide injunction issue is what's at the heart of what was discussed last week at the Supreme Court. But today's news is bad news for Venezuelans. Because this Trump administration is aggressive and looking to immediately deport individuals who entered the United States over the last couple of years. Guys, if you're faced with aggressive enforcement actions against you, you can contact us at McBean Law to work with you on the matter, or work with a local attorney on the matter. But certainly get an attorney. For us, we are taking retainer agreements now. Just so you know, we are taking retainer agreements for individuals who are very high risk for enforcement activities, so that we can get to work right away on their case and do like a motion for to stay the action or bond or habeas. We are gearing up in that manner. So just keep that in mind, that we are accepting retainers for that purpose. Guys, I'm going to jump off. I have consultations starting momentarily. Reach out to us at McBean Law 914-898-9488 or at info@mcbeanlaw.com. You could email us your request for an appointment. Thanks so much for being with me in this one, and I will see you guys in the next one. Bye-bye.